Retaliation isn't just unfair, it's illegal. If you've been demoted, harassed, excluded, or even terminated after asserting your rights, it's important to understand that the law is on your side. Let's start by defining what retaliation is in a legal context. Retaliation occurs when an employer takes adverse action against an employee for engaging in protected activity. This could include reporting workplace discrimination or harassment, filing a complaint about unpaid wages or unsafe working conditions, requesting a reasonable accommodation for a disability or religious practice, taking protected leave under laws like the FMLA or CFRA, participating in an investigation, lawsuit, or whistleblower action. Protected activity isn't limited to filing formal legal complaints. Even internal reports to HR or your supervisor can be legally protected. Now let's talk about what retaliation looks like. It can include termination or demotion, pay cuts or denied raises, sudden negative performance reviews, changes in job duties meant to humiliate or sideline you, hostile treatment or exclusion by management. These actions are considered retaliation if they would discourage a reasonable employee from asserting their rights in the future. So what can you do if you believe you're being retaliated against? Step 1, document everything. The foundation of any retaliation claim is evidence. Start keeping detailed, chronological records of when and how you engaged in protected activity, any changes to your job duties, pay, or treatment following that activity, conversations or actions that suggest you're being targeted, witnesses who observed retaliatory behavior. Also, save all relevant emails, memos, and written performance evaluations. These records can help show a clear timeline between your protected activity and the retaliation that followed. Step 2, follow internal reporting procedures. Before taking legal action, use your company's internal procedures. Report the suspected retaliation to HR or an appropriate supervisor in writing. Be specific. Describe what you did, when you did it, and how the adverse treatment followed. This gives your employer an opportunity to investigate and correct the behavior, and it strengthens your case if they fail to act. Keep a copy of every communication for your records. If you're uncomfortable reporting retaliation internally, or if the retaliation is coming from HR or senior leadership, you may want to consult an attorney first. Step 3, know the laws that protect you. Several laws protect employees from retaliation. Title VII of the Civil Rights Act, for discrimination or harassment complaints. FLSA, for wage and hour claims. FMLA and CFRA, for protected medical or family leave. OSHA, for reporting unsafe work conditions. California Labor Code 1102.5, for whistleblower protections. Depending on the circumstances, you may have grounds for a state or federal retaliation claim, and potentially for additional claims, such as wrongful termination or emotional distress. Step 4, file a complaint with the right agency. If your employer does not resolve the issue, or if the retaliation escalates, you can file a formal complaint with the appropriate government agency. That may include the Equal Employment Opportunity Commission, EEOC, the California Civil Rights Department, CRD, the U.S. Department of Labor, or other relevant state labor boards. These agencies can investigate your claim, mediate a resolution, or issue a right to sue letter so you can take legal action in court. Step 5, work with an employment attorney. Retaliation cases are highly fact-specific. An experienced employment lawyer can evaluate the strength of your case, help you file complaints or lawsuits, negotiate a settlement or severance package, represent you if the case goes to trial. At Employee Law Group, we help clients protect their rights, recover lost wages, and pursue damages for emotional distress and career harm caused by retaliation. And we do it with professionalism, discretion, and clarity. Step 6, focus on recovery and reputation. While protecting your legal rights, don't forget to protect your future career. If you're still employed, Document your contributions and stay professional. If you've been terminated, update your resume, seek out supportive references, and consider talking with a career counselor or mental health professional. Retaliation may feel like a setback, but with the right legal support, it can become a turning point towards something better. Moving forward, retaliation is illegal, and you don't have to face it alone. By taking the right steps, documenting your experience, reporting the behavior, and consulting legal counsel, you can protect yourself, hold your employer accountable, and move forward with confidence. Thank you for watching. If you believe you're experiencing retaliation in the workplace, contact the Employee Law Group for a confidential consultation. We're here to help you protect your rights and your professional future.